All right, let's get started, everyone. Like I said, good afternoon. My name is Rachel. I am the Marketing, Communications, and Membership Manager here at the Chamber. And I just wanted to give a quick little introduction to our webinar today, COVID-19 Employer Rights and Responsibilities. First of all, we would like to thank today's sponsor, Great Lakes Bay Michigan Works. And like I said before we get started, I'd like our attendees to note that we will be using the Q&A icon at the bottom of your screen for any questions you would like answered during our webinar. You can submit a question at any point throughout the webinar, and it's, like I said, it's right at the bottom of your screen, the Q&A icon. Now it's my pleasure to introduce our moderator, John Kaczynski. He's a Bay County native and serves as the Director of Governmental Affairs at Saginaw Valley State University. In his role, he interfaces and lobbies on behalf of SVSU in Washington, D.C., Lansing, and throughout the Great Lakes Bay region. John has worked on various policy projects for state and local government in Michigan. These include transportation, brownfield redevelopment, and community planning projects. He currently serves on the Great Lakes Bay Region Workforce Development Board, the City of Frankenmuth Planning Commission, and the Kochville Township Downtown Development Authority Board. John, would you like to take over?
Thank you, Rachel, and it's my pleasure to moderate today. Welcome to everybody, and it's my honor to introduce our two guests today who will be talking about COVID-19 employment issues. And our first guest today is Jamie Hecht Nisidis. Ms. Nisidis serves as chairman of the firm's executive committee at Braun Kendrick. Jamie's practice focuses on litigation with an emphasis in the employment defense, insurance defense, civil rights defense, and appellate practice areas. Jamie has successfully represented private and public entities in the state and federal trial and appellate courts in Michigan and before the Michigan Department of Civil Rights and Equal Employment Opportunity Commission. Jamie has regularly advises clients on employment-related matters and provides legal opinions on insurance matters. Jamie was appointed by the Chief Judge of the United States District Court for the Eastern District of Michigan to the court's Local Rules Advisory Committee and served on that committee for 6 years. Jamie has also twice been appointed by the Chief Judge to serve on the U.S. Magistrate Judge Merit Selection Panels. Jamie is a past winner of the Thomas M. Cooley Law Review Distinguished Brief Award, an annual award given for the best brief submitted to the Michigan Supreme Court. Jamie serves on the boards of Underground Railroad, Inc., and Peace Lutheran Church. Jamie is a graduate of Leadership Saginaw. Welcome, Jamie. Along with Jamie is Eric Morris. Eric also works at Braun Kendrick in their business and healthcare practice groups. He specializes in meeting the legal compliance and strategic needs of those navigating the complex healthcare regulatory environment. Eric advises hospitals, physicians, and other healthcare providers on matters related to Stark law compliance, HIPAA, HIPAA privacy and security, physician employment, and medical office leasing. Eric also assists clients in negotiating information technology, equipment leasing, and other vendor contracts in the healthcare sector. He also counsels companies and individual healthcare providers contemplating strategic partnerships, joint ventures, and affiliation agreements. In addition to his work in the healthcare sector, Eric frequently counsels both public and private clients on a range of matters including labor relations, employment issues, regulatory compliance, and risk management. In addition, Eric has experience defending employers in labor grievance arbitration and employment contract arbitration. Prior to joining Braun Kendrick, Eric worked in-house with a hospital system in the Southeast, where he handled all aspects of physician contracting in addition to managing a wide portfolio of compliance matters, employee relations, and litigation management. Eric began his legal career as a financial services litigator with a prominent firm where he focused on representing broker-dealers in consumer and employee arbitration matters. He brings this experience to his transactional and regulatory practice, where he regularly counsels clients facing potential litigation with employees, vendors, and government entities. Eric is a Saginaw native and parishioner of Christ the Good Shepherd Church. He is active in the local Boy Scouts of America and the Saginaw YMCA Service Club. Welcome, Eric. And so as those bios are read, both individuals are very highly experienced in these matters and very much looking forward to the presentation they'll be giving us over the next couple of minutes. So Jamie, Eric, it's all yours.
Thank you.
Thank you. So I'll be beginning the presentation. Jamie will present in the middle and I'll close. The first thing is there's a lot of material here. We're going to try and move quickly through things that I think everyone's generally familiar with, the overview items. They are listed in the PowerPoint, and try to get to some of your questions and the more detailed issues throughout the presentation. So with that, we'll begin. So first, quick disclaimer, this presentation is not legal advice. If you need actual, legal advice on a specific matter, you need to consult an attorney. We'd be happy to help you if you don't already have an attorney that you're working with, but that's it for the disclaimer. So we're going to begin today by talking about the stay-at-home, stay safe order and the other relevant executive orders that are out there for employers. There's three main executive orders that everyone should be familiar with out of the 77. These are probably the biggest ones. So you see them listed here, and we're going to go through each of those in turn. We'll start with Executive Order 2020-36, which is protecting workers who stay at home. This is just the overview. The basic premise of 2020-36 is to provide some measure of employment security for those employees who have to stay home because they've either been exposed to COVID-19, they have COVID-19, or they're at risk of infecting others with COVID-19. The basic thing you need to understand with regard to this is that there are four basic categories of employees that are covered by this order. And if they meet the conditions of this order, they have protection against discharge, discipline, or retaliation for staying home because of these conditions. The first is if they actually test positive for COVID-19. The second is if they display one of the principal symptoms of COVID-19. And 3 and 4 are basically if your employee has close contact with anyone who has COVID or even anyone who has a symptom of COVID, they have to stay home for a period of time and their job needs to be protected during that period of time. So the first thing to understand is under the executive order, there's a lot out there about what the symptoms are of COVID-19, but at least for purposes of this order, there's three things: fever, atypical cough, and atypical shortness of breath. And I love the use of the word atypical. I just read that to mean unusual, new, or different. So if someone has, some condition that gives them a cough normally or whatever, it had to be new or different. They define close contact as being within approximately 6 feet of an individual for a prolonged period of time, and they give a lot of examples, but this is mainly close family. And if you're maybe in they use an example like a hospital waiting room, if you're in that area, you need to stay at home, and as an employer, you need to make sure that your employees are protected during that time. The timeline is below. So you have basically two triggering events. One is in order for them to return, they have to have 3 symptom-free days, and it has to be at least 7 days since their symptoms started. Okay, they can always return after a negative test result. With regard to the close contact where the employee himself or herself doesn't have the actual symptoms, you need to have 14 days since that close contact has ended, or if the individual who they think exposed them gets a negative test result. So this can be quite a long period of time. So we listed employee protections here. No discharge or discipline for those employees who qualify. The key one for employers is, you can ask for documentation about this, but you cannot discipline employees for failing to provide it. And that's a common theme that we're going to talk about. The documentation allowances and requirements under these acts is very minimal from the employer perspective. So you have to be very careful about what you're asking, and be doubly careful if you're going to discipline someone for not providing you specific information. Under this order, the individuals basically are considered under Paid Medical Leave Act, which you've already been dealing with for the last year. However, the time limit is does not apply to them. So you have to extend this leave as long as they need it. It does not need to be paid for the entire time, but it has to be extended. Now, you may terminate employees if they're qualified to return and if they refuse to return. And that's pretty much the only situation you can do These are the exemptions. You can see the list yourself. If one of these applies to you, this order does not apply to you. So kind of trying to summarize on this one, to start with, violating 2020-36, that's a violation of the Paid Medical Leave Act. There's a vague threat in the order about reporting violations to licensing authorities. They're going to, to the extent there's problems with these executive orders, the government will leverage everything that they can if they think especially if they think you're an intentional violator. And one of those would be whatever license you may have. Now I won't get into it, but enforcement under the Paid Medical Leave Act is relatively limited. It's not what I would be worried about. What I will be worried about, and what Jamie's going to talk about later, is generally speaking, when this order applies to an individual, that, in our opinion, counts as a quarantine order, and that means that they're subject to additional protections under the FFCRA, the emergency sick time provisions specifically. And that law has much stronger anti-retaliation prohibitions and penalties. So what you want to be thinking about is every time you're evaluating employees, do I come to work, do I not come to work? Do they fit in this category of 2020-36? If so, that typically is going to bump them into the emergency sick time as well, and you have to consider both. So 2020-71, this is specific to food selling establishments and pharmacies. This is basically a supplement to the stay-at-home, stay-safe order that puts on additional measures for these specific categories of businesses. I don't know if anyone on the call today is in this business, so I'm going to give you just the very basics on this. I'm not going to kind of go through it in too much detail, but the key is you got your definition of a food selling establishment, and that is defined as grocery stores, convenience stores, restaurants that sell groceries or food available for takeout, and any other business that sells food. So that's a pretty broad brush there. So, one example is the corner store or whatever. They're not a restaurant, but they are definitely a food selling establishment. And this has heightened safety and sanitation and mitigation requirements. And the key thing for employers is under Executive Order 2020-71, you're required to allow your employees who are in a vulnerable population to either have a lower exposure work assignment or to take an unpaid leave of absence. And in that situation, they would specifically qualify for unemployment. So you may get a lot of questions if you're in this category, and it may be difficult to navigate this because the definitions are all, excuse me, I got distracted there. The definition of vulnerable population is fairly broad. It's if someone's, I believe, over the age of 60 or older, or if they have an underlying condition. The other thing is you've got a 12-hour window to notify your employees and your vendors if somebody at your establishment tests positive. So that's something to keep track of. So we'll go, yeah. So this just came out yesterday. This is EO 77. This is the newly revised stay-at-home, stay-safe order. This is one that we've been dealing with for a long time. Governor Whitmer has been sort of incrementally adding things to it. There weren't, the foundation still remains the same, okay? So all public gatherings outside of a single household are prohibited unless there's an exception. That remains. Now, there's a lot more exceptions than there were back in March, but nonetheless, that's still the same basic methodology is you can't have people gathering, you can't have your employees gathering unless you have a reason to do so. And that follows down to in-person business operations are still generally prohibited unless you have an exception. So the three categories that we have, and I think everyone on this call is probably familiar with these. If they aren't, get with us offline and we'll help you out. Businesses who employ critical infrastructure workers, that category remains basically the same as under all the other executive orders. The second is workers who perform minimum basic operations. So your minimum basic operation workers are for those businesses that are not critical infrastructure businesses, but they need to continue to operate to meet payroll, to allow other workers to telework, and to make sure that your inventory or your place of business is safe and secure. The third category is resumed activities. And this is where the governor has just been adding to the list of what is allowed to be resumed. So what we have here are We have workers who process or fulfill remote orders. We have the garden stores, nurseries, lawn care, pest control. We have the moving or storage operations. We have work that's traditionally performed outdoors. We have the construction industry, the real estate industry, and two new ones that are in this order, which is manufacturing startup workers and actual manufacturing activities. So the way it works is on manufacturing, employees who are necessary to begin the process of manufacturing plants, preparing them to work, they can go to work immediately. They can go to work right now, they can go to work today. Generally, manufacturing employees can return to work on May 11th as long as the facility has been prepared with all of the mitigation measures. So if you build something or make something, assemble something, whatever, you can go back to work on Monday. The issue is there's a lot of hoops to jump over, and you want to make sure that you've got documentation that you followed all of these measures. So how do you know what you need to do as an employer? The first thing you need to do is you need to put yourself in one of these categories, okay? So there's kind of layers of the onion here, right? Everyone has to follow a certain set of requirements no matter what type of business you have, if you have people reporting in person. On top of that, the next category are your garden stores, nurseries, lawn care, pest control, moving storage, outdoor work. That has an additional set of requirements on top of it. Additionally, construction specifically has a separate additional set of requirements. Manufacturing has the newest yet separate set of requirements, and they're quite substantial. I don't know the breakdown of those participating in our call, but you need to take a look at 77 and go through the list and make sure that you can check all those boxes, because employee complaints are still out there, and that's just the way it is. The final one is any store that remains open selling essential items. So this would be your even your corner store that sells some food. There's an additional set of requirements for them. So there's all these different items that you have to tick off in order to be able to go back to work. So here's the basics. So you need to consult Executive Order 77, and you need to find out if Executive Order 71 also applies to you. You still have to designate your workers in writing, and they fit into one of those three categories. They're either critical infrastructure workers, they're either minimum basic operation workers, or they're resumed activities workers. This is just a note, this has been in place for a while, but I suspect a lot of companies may not have gotten around to it yet. Any company that has any level of in-person operation needs a COVID-19 preparedness and response plan in writing. Masks are required for anyone who can't consistently maintain 6-foot social distancing, and face shields are strongly recommended for those who are within 3 feet of each other on a regular basis. You as the employer have to provide the masks to the employees. So basically the advice here is you look at 36, 70, and 70, 36, 71, and 77, and you're going to find out which category you fall into and adopt the specific measures that you need to.
Right, so I'm going to talk about the Families First Coronavirus Response Act, which I'm sure many of you have been dealing with probably for the last 5 weeks or so. So I'm going to go through it again fairly quickly. There really are 3 particular provisions of that much larger act that apply to employers. The first is the Emergency Family and Medical Leave Expansion Act, which temporarily expands FMLA leave to provide emergency leave for employees who can't work because their child's school or place of care is closed. And the second is the Emergency Paid Sick Leave Act that provides paid sick leave to employees who are unable to work for a variety of reasons that are related to COVID-19. And then, of course, there's the tax credits that apply to both of those acts when employers pay wages related to those acts. So these are temporary measures, and they only apply between April 1st of this year and December 31st of 2020. So who is covered? So generally, both of these acts cover employers who employ fewer than 500 employees, as well as public agencies. There is an exemption to the child care leave requirements of both acts for employers with 50 or fewer employees, but only if compliance would jeopardize the viability of the business as a going concern, and I'll talk about that more later on. The Emergency FMLA expansion also broadens the category of employees that it applies to as compared to the traditional FMLA. The requirements for having worked a year or a certain number of hours do not apply. The employee simply needs to have been employed for at least 30 calendar days in order for those provisions to apply. Emergency Paid Sick Leave Act covers all employees regardless of length of employment. The only exceptions here are that an employer may elect to exclude certain employees who are healthcare providers and emergency responders. So I'm going to start off with the Emergency Family Medical Leave Expansion Act. That really applies in one situation. It is employees who are unable to work due to the need to care for a child whose school or place of care has been closed or their care provider is unavailable for reasons related to COVID-19. And the main takeaway here is that the employee only has a need for this leave if he or she has no other suitable person available for care. So in theory, you couldn't have both spouses taking that leave at the same time because in theory, the other perhaps can provide the care. So it's similar to traditional FMLA. There's up to 12 work weeks of this leave available, but again, only through the end of the year. It's important to know that if you're already covered by FMLA, that this is not an additional 12 weeks of FMLA coverage, but simply a total of 12 weeks in a 12-month period. So if, for example, an employee has already taken 6 weeks of leave because they had a baby or 4 weeks of leave for surgery, then they only have, either 6 or 8 weeks left that they can use for the child care leave requirements under the expanded FMLA provisions. And expanded FMLA can also run concurrently with other types of leave. So if you have a different type of leave of absence policy, you would also run that concurrently. So the paid leave requirements for the expanded FMLA are that the first 2 weeks are unpaid, but an employee can use any paid time off that they may have, including the emergency paid sick leave that we'll talk about in a minute. After 2 weeks, the employee is entitled to 2/3 of the employee's average regular rate of pay for the time that they take, up to a maximum of $200 per day or $10,000 in the aggregate. And as I noted, the employer may require an employee to take other paid leave concurrently with that 10 weeks after the first 2 weeks. The expanded FMLA has the same prohibitions against interference and discrimination that FMLA traditionally has. Interestingly, there's only a private cause of action available if the employer was already covered by FMLA. Otherwise, the enforcement remedy is through the Department of Labor Wage and Hour Division. So the Emergency Paid Sick Leave Act is much broader. There are 6 qualifying reasons for leave under the Emergency Paid Sick Leave Act, but the time periods that leave has to be required are much less. So the 6 qualifying reasons are listed on the slide. The first 5 are really the only ones that are in play here. Number 6 is something that is to be defined later if perhaps there's another condition or a different strain of this virus that comes out. So the first is that the employee is subject to a quarantine or isolation order related to COVID-19. So that's what Eric mentioned earlier. If an employee is allowed to stay home under Executive Order 2020-36 because they've either had close contact with somebody or they have symptoms themselves, then they would be unable to work due to a state quarantine or isolation order and would be entitled to emergency paid sick leave under the Act. The second is that an employer has been advised by a healthcare provider to self-quarantine due to related to COVID-19. The third is someone who's experiencing symptoms and seeking medical diagnosis. The fourth is someone who's caring for someone who's subject to a quarantine or isolation order, or who's caring for somebody who's been directed by a healthcare provider to stay home. And then number 5 is really coextensive with the expanded family medical leave provisions, and it relates specifically to someone who has to care for a child because the school or place of care is closed or their child care provider is unavailable. So specifically the quarantine order, as I mentioned, this would apply to like an executive order such as 2020-36. If someone tests positive, or has symptoms or has close contact with someone. It does not apply to everybody who has to stay home because of the judge's stay home or the governor's stay home order. In that instance, the employer does not have work for the employee, so the paid sick leave provisions do not apply. The second reason, of course, is advised by a healthcare provider to self-quarantine. That applies if the healthcare provider has advised the person to stay home because they either have COVID-19 or they may have it, or what we're seeing most often is because an employee is particularly vulnerable to COVID-19. So that applies to employees who have chronic conditions like diabetes, heart disease, maybe COPD, that type of thing. We're seeing a lot of employers who have employees whose doctors have told them they shouldn't go to work because they're particularly vulnerable. And so they'd be entitled to paid medical leave in that instance. The fourth one is someone who's experiencing symptoms and seeking medical diagnosis. So in this one, the specific symptoms they require are fever, dry cough, shortness of breath, and then it broadly expands it to any other COVID-19 symptoms identified by the CDC, which I think at this point has gotten quite a bit broader. The employee actually has to be taking affirmative steps to obtain a medical diagnosis. So this is really just during that time period where they're not sure and they're seeking diagnosis. They can't just decide themselves to stay home. They have to affirmatively be seeking medical diagnosis. But as Eric mentioned, the documentation requirements here are minimal to non-existent for employees. So there's not a lot you can do to police it. The last reason that we'll talk about is the fifth reason. Fourth, I must be off a couple. One is caring for an individual, I apologize. So for example, if a family member, somebody who resides in the person's home, or someone that they have a close relationship where you would expect the employee to take care of the person, they may have to stay home to take care of someone who is subject to an isolation order or who's been advised to self-quarantine. And then the last one is caring for a son or daughter, which is really the same leave requirement as for the expanded family and medical leave, but they're entitled to paid sick leave up to the time required under the Paid Sick Leave Act for that same reason. And again, there has to be no other suitable person available for care of the son or daughter for this to apply. So how much leave do they actually get under the Emergency Paid Sick Leave Act? Full-time employees are entitled to up to 80 hours of paid sick leave. And full-time is defined by the Act to be at least 40 hours a work week. For part-time employees, it's just basically done on a pro rata basis. So if the part-time employee works 20 hours a week, then they're going to get 40 hours of paid sick leave. If the employee does not have a normal schedule, then there's an averaging done to determine, but again, it's based on the idea that they're entitled to the same number of hours of paid sick leave as they'd work in a 2-week period. So how much do they get paid? So for the first 3 reasons, which are the quarantine order, the advised by a healthcare provider to stay home, or someone who has symptoms and is seeking diagnosis, the employer is entitled to the higher of either their average regular rate of pay or basically the minimum wage. So most employees, it's going to be their regular rate of pay. But there is a maximum of $511 per day or $5,110 in the aggregate per eligible employee. The pay requirements are different for reasons 4 and 5. So that is if you're caring for another individual who's subject to a quarantine order or who's been advised to stay home, or if you're caring for a son or daughter. In that situation, the employer only has to pay 2/3 of that amount that otherwise would be required. So 2/3 of the regular rate of pay. There's also a maximum amount applicable there, and that is $200 per day or $10,000 in the aggregate, which again is similar to the amounts required to be paid under the expansion of family and medical leave. The Emergency Paid Sick Leave Act also has a non-retaliation and enforcement provision. Specifically, employers are prohibited from discharging, disciplining, or discriminating against an employee because they took paid sick leave under the Act. An employer who violates the Act is subject to the same enforcement provisions that apply to minimum wage violations. So this is enforced by the Wage Hour Division of the Department of Labor. So for both types of leave, there are questions regarding how does intermittent leave apply. So as a general rule, an employee can only take either the paid sick leave or the expanded family and medical leave intermittently if the employer and the employee agree that the leave can be taken intermittently. For paid sick leave specifically, there are only two circumstances where an employee, even if there's an agreement, can take the leave intermittently. The first is for care of a son or daughter, and the second is if the employee is able to telework or work from home. The idea is that for the other reasons that an employee would be able to take this type of leave, they're in theory a threat of either spreading the virus or getting it themselves. So they don't want employees to be able to take the leave intermittently. Once they start taking the leave, they have to take it continuously as long as they're entitled to it. Now that doesn't mean that they automatically get 80 hours at that point, but they have to take whatever time they're eligible for continuously. And they could take another amount of time if they have some left at a later point continuously, or if for a son or daughter being cared for or teleworking, then if the employer agrees, they can do it intermittently. So how do these two acts fit together? When it comes to someone who needs leave to care for a son or daughter, basically an employee would be taking leave both under the Paid Sick Leave Act and the Expanded Family Medical Leave Act concurrently. They could take the first 2 weeks of leave up to the 80 hours as paid sick leave, and then the subsequent weeks would be paid the way that they are paid under the Family and Medical Leave Expansion, which is the 2/3. So I mentioned earlier that there is a small business exemption to both these acts. That small business exemption only applies to the child care leave requirements of the acts, and it is for employers with fewer than 50 employees. And it applies if an authorized officer of the business has determined that any of the following three things would occur. The first is that the business's expenses and financial obligations would exceed available revenue. So the first is a financial. The business wouldn't be able to keep operating if required to provide the leave. The second is that a particular employee's absence would cause some kind of financial risk or problem with operational capabilities to the business. So if it's a key employee, somebody that the employer needs, they can exempt them from the child care leave requirements. And then the third is if the employer simply wouldn't have enough workers if they provided this leave in order to be able to meet their business operations at a minimal capacity. So the employer simply needs to document that they've gone through this analysis and made this determination, and they retain the documentation. They don't send it to anybody. They don't seek a certification from the Department of Labor. They simply make the determination on their own and save that documentation in case an issue comes up. Employers are also allowed to exempt certain employees, as I mentioned, healthcare providers and emergency responders. So an employer who employs a healthcare provider can either exempt individual healthcare providers or all of its healthcare providers from the requirements of the Act. And the definition of healthcare provider is fairly broad, includes anyone who's employed at a variety of health-related businesses, including doctor's offices, hospitals, clinics, retirement facilities, nursing homes, pharmacies, etc., as well as people who work for contractors of those facilities. Similarly, there's an emergency responder exclusion, which is also fairly broad. And again, it applies to employees who are emergency responders. So for example, people who transport, so you'd have your ambulance or MMR types, provide other care and services. It includes, again, nurses and physicians, and more broadly, emergency personnel, firefighters, etc. So there are restoration rights under both of these acts. They're very similar, so I'm going to talk about them together. So an employee returning either from paid sick leave or from the expanded family and medical leave has a right to be restored to the same or an equivalent position. Essentially, they have the same right to restoration that they would have had under the Family and Medical Leave Act for those employers who are covered by FMLA. But it applies to all the employers in this instance. It does not protect an employee from actions that would have taken place without regard to whether the employee took the leave, such as layoffs. And there is a key employee designation for the family and medical leave provisions that is consistent with the key employee provisions in the FMLA. There is an exception for small employers. In this case, small employers is defined as those with fewer than 25 employees. They can deny job restoration to an employee who's taken specifically the expanded family and medical leave to care for a son or daughter if certain conditions are met, including that the position no longer exists because of economic conditions or changed operations that were resulted from this healthcare or this public health emergency. They have to show that they made reasonable efforts to restore the employee to an equivalent position, and where those efforts have failed, that they made efforts to contact the employee during a 1-year period after that if an equivalent position becomes available. So we mentioned the documentation requirements. The documentation requirements for employees seeking both of these types of leave are very minimal. The employee simply has to provide their name, the dates of leave they're requesting, the qualifying reason for the leave, and either an oral or written statement that they're unable to work because of the qualified reason for leave. So again, an oral statement is sufficient. There are some additional requirements for specific reasons that I'll talk about in a minute that they have to also provide, and then they're required to provide any additional material that an employer needs in order to support a request for tax credits. But those documentation requirements basically mirror the requirements under these acts and don't really add very much. So the specific document requirements for the different qualifying reasons are set forth on the slide. With regard to the quarantine or isolation order, all they have to do is provide the name of the governmental entity that issued the order. So in most cases, that would be the governor's office here. For being advised by a healthcare provider to self-quarantine, they just have to provide the name of the healthcare provider. They don't have to provide a doctor's note or anything else. With regard to symptoms of COVID-19 or medical diagnosis, they don't have to provide any documentation at all. When it comes to caring for an individual who's subject to a quarantine order or who's been advised by a healthcare provider, same requirement to simply provide the name of the governmental entity or the name of the healthcare provider. The requirements for caring for a son or daughter are a little bit more, but again, just the name of the child, the name of the school, place of care, or child care provider that's not available or is closed, and they have to make a representation that there's no other suitable person caring for that will be able to care for the son or daughter during that period. This is one area where there is a bit of a different requirement or an additional requirement for the tax credits. The tax credits state that you can also require an employee who's seeking to care for a son or daughter who's 14 or older during daytime hours to provide a statement as to why there's some special circumstances that they would need to be home with someone of that age during daylight hours. Healthcare coverage must be maintained under any group healthcare plan on the same conditions that it was otherwise being provided during both the emergency paid sick leave and the expanded family and medical leave coverage. The employee can be required to continue to pay their share of premiums. If they choose not to retain the coverage, then they have to be reinstated to coverage on the same terms without a waiting period when they return from leave. And I'm just going to very briefly mention the tax credits. Employers do receive tax credits against their federal employment tax deposits for any calendar quarter that's equivalent to 100% of the qualified sick leave and family leave wages that they paid during that calendar quarter. That also includes qualified healthcare plan expenses that relate to those wages and the amount of the employer's share of Medicare taxes imposed on those wages. So I'm going to turn it back to Eric.
Okay, so I know that we're bumping up against our time here, so I'm going to try and go quickly through the Paycheck Protection Program. This is not going to be a comprehensive discussion, but I'm going to overview some of the recent guidance, talk about how it works with some of the other programs, and try and answer some of the common questions that I've gotten before. What you need to know is that there's a frequently asked questions document out there done by the Small Business Administration that has a ton of questions and answers we can talk about. They're also issuing what are called interim final rules, which is basically regulations on a very emergency basis. There will be another one expected very soon, so keep your eye open for that. Overall, if you've already received a paycheck protection loan, your main goal is complying with it and getting your loan forgiven. If you haven't received one yet, I'm not going to talk about eligibility and all that, but if you haven't received one yet, you think you might be eligible, get with your bank, whoever you have a relationship with immediately and try and see if you can still get it. But basically, once you receive the money, you've got 8 weeks to spend it. You spend it on qualifying eligible expenses. you'll get forgiveness if you jump through all the right hoops. So basically, you can spend it on payroll costs, salaries, wages, commissions, tips, bonuses, paid leave, but not Families First Coronavirus Response Act. So not the stuff that Jamie talked about. That's the separate tax credit. So if you're paying somebody to be off for 2 weeks, you cannot seek forgiveness under the PPP for that pay, and you can't use you should not use your PPP money to pay them. Okay, that should come from a separate pot. Utility payments, rent payments, mortgage interest payments, interest on other debt. Something important to note: you cannot pay anyone during your PPP loan. Well, you can pay them this, but you cannot be forgiven on it. But you shouldn't use PP money to pay anyone who makes more than $100,000 a year on a pro rata basis. So I think that's what, $1,900 a week or something. So for some of your higher compensated employees, you're only going to spend Paycheck Protection up to that amount during that 8 weeks, and they'll get paid anything above that out of other funds. The basics on getting it forgiven. Number one, everyone's probably heard this. You have to spend 75% of the total amount on that first category, payroll costs. And you have to worry about getting a reduction for a couple of different reasons that we'll talk about very quickly. So we'll go ahead. Okay, here's the main things to understand. There's an employee retention tax credit out there that's a bigger tax deduction against your payroll taxes. If you took the PPP loan, you cannot use the employee retention tax credit. We talked about you can't use PPP to pay the wages that Jamie just discussed, and you'll not get forgiveness on that. One thing that has come out recently, employers may still choose to defer payroll tax payments under the CARES Act, but if you took a Paycheck Protection loan. However, you cannot continue to do that. As soon as your lender forgives your loan, you have to pay back anything that's not, that's been deferred. So it truly is temporary and short term. One thing that we've got is there's been a lot in the newspapers about businesses taking these loans that shouldn't have. In other words, businesses who had access to other funds and were big companies or wealthy companies. So they've put in a safe harbor that says if you probably shouldn't have taken the money because current economic uncertainty made the loan request necessary, then you can give it back and face no consequences. And that deadline is up until May 14th now. Here's a small note. If you got $2 million or more in Paycheck Protection, there's indications that you will be audited. All the other smaller loans are subject to random audits as well. The other new piece of guidance is one of the big questions we have is, I'm trying to spend my money and the employee won't come off unemployment and come back to work. He or she won't take the job back. So there's guidance out there now that says if you make a good faith offer in writing to rehire the employee and they reject it, that employee's rejection will not punish you on your forgiveness under the Paycheck Protection. But again, it has to be in good faith, has to be in writing, and you got to document that they said no. But that's good news for employers. So here are some quick common questions that I get. When we're determining how many full-time equivalents we have to see if we kept enough employees, how do I do that? Generally speaking, most people are saying that 30 hours per week equals 1 FTE. There's some banks out there that are saying 40, and there's some articles out there that are talking about 40. The regulations don't specifically mention that. I would run the numbers under both. Again, there are ways to rehire workers that you've previously laid off in order to avoid getting dinged on your loan forgiveness, but you got to do that right now. You got to do it soon, and you can't wait because your loan forgiveness is judged every pay period during that 8 weeks. So you can't, in my opinion, now that there might be guidance on this that changes this, but the way I read the law is you can't wait until the end to rehire everybody for a week and have that save you from getting your forgiveness knocked down. The last one is the expenses have to be incurred and paid during the 8 weeks. So you may have to do a special payroll, right? Because it's incurred and paid. So you can't pay them a week before. And if you paid your payroll for the first week, that's really in arrears for work that happened outside of the 8-week period, you shouldn't do that. So remember, the expense has to both be incurred and paid during the 8 weeks. And then I'll skip the last two. Here's the recommendations on what we think you should do. Try to get that money in a separate account if you can. If you can't, at least limit the number of times that you're dipping into it to spend it. Because every time you spend the Paycheck Protection money, be expected to document it. If you have any concerns that you shouldn't have taken a loan, figure that out before May 14th. And then I recommend that you start running your comparisons on how many employees you got back, just to see how much your loan might be forgiven. Only stay in those categories that we talked above. Do not get aggressive on it. In this environment, I don't think you want to be the test case for spending it on something that you shouldn't have. And then the last one's quite simple. Get your employees back on payroll as soon as possible. Don't wait until the last week. So final quick reminders before we jump into some questions. Review each employee request for leave separately. Review them on a case-by-case basis. Consider a sick leave policy and FMLA policy for this area. There's resources out there. We can help you with that. Other HR consultants can help you with that, whoever. Develop some request forms so that you get your information for these different types of leave. So if you get audited, you can show them a piece of paper that says, this is what I did. And then just have these questions in your mind. This last one is a good thing. When employees are asking, I want to be off work, or I can't come in, or whatever, start working down the tree. Do they meet any of the 6 or 5 conditions under the FFCRA? Okay, yes, then give them the leave. Do they have a serious health condition? If FMLA applies to you, you got to think of it from an FMLA provision as well. If that doesn't, if you're still going through the decision tree, you have to consider Americans with Disabilities Act. Did they ask for an accommodation? Should you give it to them? And then finally, do you have those additional protections under EO 2020-36 or 2020-71? So I know that that's a lot of information. We got some questions here. I will kick it back to John.
Yeah, Eric and Jamie, thank you very much. And we're going to spend the last 10 minutes here just kind of flying through some questions. And the first one comes to us, broad-based one. Eric, you were alluding to it at the end about employees possibly refusing to come back to work. But what can employers do when employees refuse to come back to work after a layoff related to the fear of COVID-19, and or receiving unemployment plus federal benefits?
So you're in a difficult position. I can't really lie about that. What we've seen a lot of employers do, number one, the Michigan Unemployment Agency is still saying that if you reject work for no reason or for not a valid reason, you should not be eligible for unemployment. So what I recommend is that you do a written recall notice and written reminders to your employees that, hey, we are, whatever your category is, resumed activities, minimum basic operations is critical, whatever your category is, we are critical, therefore we're continuing to operate, we recall you back to work. And if you have any concern about it or you think any of these different programs may apply to you, please contact us immediately. If you do not have a valid reason not to be at work, or if you just don't respond, we're going to consider you voluntary quit. And that's a difficult thing to say to employees, but they have to understand that if they're not working within the confines of the law, number one, they won't have a job with you when this all ends. And number two, they might lose their unemployment. That's about the best you can do.
Okay. Next question comes to us, and it's we've heard a lot about size of guidance for critical employees in different categories, but a broader question here was, could you give some examples of what type of business falls into the various categories that were mentioned earlier? The specific person works in the insurance and for an insurance agency.
So Jamie, I'll take that. I looked at that one. So I'll just go specifically on insurance. The insurance industry is a critical infrastructure industry, but only to the extent that your work cannot be done remotely. So if you go into EO 77 and you just hit Control F, find, and you pump in insurance, you're going to find that you're addressed under critical infrastructure. So you're allowed to do in-person work if you can't do it remotely. And if you can do it remotely, then you're not in a special category anymore.
Thank you. Another question. If we allow remote work, do the employees still qualify for the employer paid sick time if their kids are out of school?
I can take that one. So only if they have a need to care for the child while they're working remotely and it causes them to be unable to work remotely. So for example, if you had older kids, that probably wouldn't be a basis, but if they were younger children, you might have a basis, and that would be a situation where they could potentially take that leave intermittently if the two parties agree to that, maybe come up with a schedule that would work for that. But they have to be unable to work because of the need to care for the child, whether they're working remotely or working on site.
Thank you. Next question. What if an employee was fired during the 8 weeks and you can't get a replacement in place within the 8 weeks?
So I'll take that one. If they refuse to return and that's why they end up not working for you anymore, you're going to get some relief based on that guidance that I discussed, where the penalties will not apply to employees who just refuse to come back to work even though they're allowed to. If they get fired for some other reason, you're going to have to do the best that you can do with regard to that employee. We don't have any guidance on that, but I think that if in good faith the person needed to be terminated, I think that there will probably be some way for you to not get dinged on forgiveness. The other thing is to make sure that you try and get enough hours with other employees to keep your FTE count up. Because again, that's based on number of hours. It's not just based on head count. So you can at least limit your damage to that one employee by making sure that you try and keep the hours up elsewhere.
Thank you. And Eric, there was actually a question that was put up on the Q&A board a little earlier about paid medical leave, and you were able to answer that one offline. But, should we pay out paid medical leave if employee requests time off and not sick or no symptoms? Our company is essential workers in healthcare.
Yeah, so this is a difficult one, right? Because as Jamie talked about, and I'll let her comment on this one too, healthcare, if you truly meet the definition of healthcare provider and healthcare workers, of course, the FFCRA does not apply. And so at that point, I think the answer is if you've decided to designate those people as healthcare workers and you're not giving them federal emergency sick time, then the question is, I think you need to follow your normal policies that are in place and not necessarily, say that nobody gets paid time off. Now, I think it'd be reasonable to say no one gets vacation if you're that busy, but if they're sick for some other reason or something else, I don't know if Jamie, if you want to.
Yeah, I think that's fair. And the other thing to take into account is the Executive Order 2020-36 that has the non-retaliation provisions, that also has an exception for healthcare providers in terms of the policy statement that employees who are ill are allowed to stay home. But it also says something to the effect of if it meets your occupational, your requirements for your company. So if it would be a risk to your other employees or to customers or patients to let somebody work who's ill, then I think you're going to not want them to be working, and then apply whatever other paid time off or unpaid time off you may have available, even if you choose to exempt them as a healthcare provider from the requirements of paid sick leave.
Okay,
Yeah, and you do need to take action to exempt them from FFCRA.
Yeah, it's not automatic. It's a choice by an employer to choose to use that exemption.
So make sure that if you're in that category, make sure somebody's made that designation, or if you haven't, make sure that you're paying that sick time or else you could have some trouble.
Okay, thank you. And if anybody has any more questions, feel free to put them up on the Q&A board. I've got one more in the queue, and this is a pretty long one here. I recently had a discussion with a company owner. They're having their secretary come back on Monday the 11th, and employees meeting on the 18th. One employee does not want to come back even for the meeting right now. He lives with his parents and says they may be at risk. There's a question of whether this is COVID related or if he simply prefers to continue making the equivalent $24 an hour on unemployment as opposed to his average $13 an hour wage. If the employee refuses to return and is replaced, will the employer be sued or be forced to rehire him and let the new person go?
I can take that one. So currently there isn't anything that protects an employee who lives with somebody who is vulnerable to COVID-19. So if it was the employee himself who had a health condition and was advised by a doctor to stay home, that would be a different scenario than someone who lives with someone who's vulnerable. And at this point, there's nothing to indicate that that person, if they're otherwise required to go to work because they're a critical infrastructure worker, perform, minimum basic operations, resumed activities, or any of those, and have been so designated by their employer, and they themselves are not sick or haven't had close contact with someone who is sick, then they can be required to come back to work. Now, the employer certainly could consider whether or not to allow that person to remain on a unpaid leave of absence if they don't want to lose the employee during this time, but there's nothing that would require that.
Yeah, and I'll add on to that. Depending on how adversarial it is, the way to go, in my opinion, is to present them with a application for leave, under the FFCRA, the emergency sick time or whatever. Have them fill it out and ask them how they qualify. And when they don't qualify, you've got documentation saying, we had the discussion, we don't believe that you qualify for this, therefore we expect you to be back. And that'll help protect you. You can't stop anyone from filing a lawsuit. And there will be, unless this liability protection gets enacted by Congress, there will be a lot of lawsuits. But at the end of the day, you got to document why you did what you did the best that you can, act in good faith, and continue to run your business so that you can survive this.
Okay, thank you. And Eric, Jamie, any other final comments? That was the last question I had.
Thanks for the opportunity.
Perfect.
Yeah, thank you.
Well, thank you to both Eric and Jamie and to Braun Kendrick for coming to speak today to our very large audience. There's about 40 plus participants at one point. And before I turn it back to Rachel, I just want to thank Bay Chamber for this opportunity. So I hope everybody's got a great weekend. And Rachel, back to you.
All right, thank you, John. That's all we have today for this webinar. We would like to thank all of our attendees today, especially John for moderating today's event. We would also like to thank Eric and Jamie for sharing their insights on how employers can navigate their rights and responsibilities during this difficult time. For all of our attendees, please look for more valuable content in the coming weeks from the Chamber that will be aimed to help you and your business as the economy reopens. We have our Facebook page, we have our Chamber website, we have a lot of valuable information on both of those, with both of those resources. So, and if you have any questions or concerns, you can definitely contact any member of our staff and we'd be happy to help you. And with that, have a great day. Thank you very much.